Hello and welcome once again, Disability Law Show. Good to have you along. If you're in Ontario, BC or Alberta, welcome to the show. John Scholes here as always, and back by popular demand. Look at that, James Fireman, partner, Samfiru, Tumarkin LLP, the most positively reviewed disability law firm in this country. You can look it up and confirm that, but I tell you true, that is exactly what they are. 1-855-821-5900. That would be the phone number anytime. That'll pop up on your screen throughout the show to contact James and his team. help@disabilityrights.ca works. And lots more contact we'll give out through the show and refer to our radio shows, play some phone calls from that over the next 30 minutes. But we got a busy show, James. Today, what you need to know about returning to work from LTD. We will cross that path here in just a bit. But brother, we always start with the week that was. How's your week been?
Really good, John. And I actually wanted to tie in the theme of the show, returning to work while you're on long-term disability, with the week that was, and talk about a recent case that I had with a client who, in fact, did return to work while she was entitled to LTD and was still actually entitled to continue receiving benefits. Because that's something that a lot of people don't necessarily understand. Just because you might be able to return to work in some form does not mean that automatically all of your benefits are going to be cut off. So let me explain. There's a couple concepts that you really need to understand in order for this to make some sense. So first of all, I want to talk about the change of definition. So during the first 2 years that you're entitled to receive long-term disability benefits, the test is whether or not you are disabled from your own occupation. And during that time, typically, if you are able to work, especially if you're able to return to your own job, then you're not going to be entitled to continue receiving benefits unless it is on a very limited basis. After those 2 years, though, the definition changes, and it becomes whether or not you have a disability that prevents you from doing any occupation. Now, on the surface, that is a more difficult test to pass. But in practice, there are actually some things about that test that are applied which actually make it somewhat easier in some circumstances. And in particular, what I'm talking about is a thing called the commensurate earnings test. And that's often not even written into the policy itself. It is just something that the insurance companies have to abide by, because if they don't, and it comes before a judge in a court, they're going to say, well, no, you have to actually look at what this person ought to be earning or what the commensurate earnings would be for this person. And if they're not able to meet that test, then they're going to be entitled to benefits. And that commensurate earnings test is about 60%. So let me make this a little bit more simple. If you are not able to earn 60% of what you had been earning before you became disabled, after the 2-year mark, you are going to be entitled to at least some of your benefits. And so let me work this back to the client that I had recently. So this woman had a very significant issue with her legs, and she needed to elevate them on a regular basis. And because of that, she couldn't return to the job that she had, which was in a very confined space. And she was earning quite a bit of money. After the 2-year mark, she was able to go back to an administrative job that allowed her the freedom to be able to raise her legs as she needed throughout the day. But she was earning a lot less money. She was earning less than half of what she had been before. Even on a full-time basis, she was still earning less than half of what she had before. But because it was less than 60% of what she had been making before, she was entitled to receive benefits. It wasn't the full amount. There was a reduction based on what she was earning. But she was able to earn a significant amount of benefits. Now, the insurer didn't recognize that, so that's how I became involved. She came to us when the insurer cut her off, but we were able to successfully get her something like 7 or 8 years worth of future benefits, even though she was continuing to work on a full-time basis. And so that's something really important for anyone out there who is on disability right now to understand, that you may well be able to return to work in some form and still be entitled to receive benefits. And if you're not sure about your situation, if you're not sure about your policy, there's a very simple solution. Give us a call. We're more than happy to take a look at your policy and give you some advice whether or not in your situation you might be able to return to work and still be entitled to receive benefits.
That commensurate income number of 60, 65%, whatever it is that generally what you would receive on LTD anyway? Is that what your coverage would be? So they're kind of equaling that? Yeah,
it's a good rule of thumb. If you are not able to earn enough money to replace dollar for dollar what you're earning on LTD, there's a real good chance that you wouldn't pass that commensurate earnings test and therefore be entitled to receive at least some benefits. That's not a hard and fast rule, but if that's the situation you find yourself in, more than likely you're going to be entitled to benefits, and if you're not sure, give us a call.
That's if you return to your own job. What if it's the case where you may return to some other type of job? Does it, again, commensurate income apply?
Yeah, that's really where it does apply. It's after the 2 years when it's the any occupation occupation test. So after that 2-year mark, when they look at whether or not your disability prevents you from doing any occupation, it's any occupation where you could earn at least 60%, 65% of what you had been making before you became disabled.
Have you, in your experience, have you found insurance companies kind of stretch the boundaries on that a little bit as far as what they're trying to get you to do as far as employment is concerned? We've always talked about the concept of, you're a brain surgeon or a concert pianist and they tell you to go flip burgers, for instance. I mean, you're probably not going to make 60% commensurate income, but it's also not really something you should be doing.
You know, it's interesting you should ask that question in the context of this particular client that I'm talking about. Because after her 2 years were up, she was searching for something to do, and she didn't immediately go to this administrative job that I had been talking about. And what she decided to do is to groom dogs, because it was something that she could do on her own time, and it allowed her to lift her, to elevate her feet as she needed. And so she did that for a while, and her insurer said, okay, well, that's your lifestyle choice that you've made, and because of that, we're no longer paying you benefits. That was the rationale that they used. And you can imagine, I mean, she was earning well into the 6 figures before she became disabled. And as a dog groomer, particularly one who'd only been doing it for a month or two, she was not earning a significant income from that, and it was nowhere near the commensurate earnings test.
Right.
So yes.
The point.
So the short answer, John, is yes, they do tend to stretch the boundaries of what they're entitled to do. And if you're concerned at all that your insurer is doing that in your situation, give us a call.
Again, 1-855-821-5900 anytime to reach James and his team. I'll give you another website, pocketemploymentlawyer.ca. Now, you may have heard and used that website before. We've talked about it with Leor and the Employment Law Show, but there's also a lot of crossover, and I know James will back me on this, between disability law and employment law. They shake each other's hand quite often. So Pocket Employment Lawyer, although it has to do with a lot of employment law and a lot of employment education, there's a pretty robust section on disability law there as well, James. I know you've used it, and we've always referred people to it. So anytime you want to use that, if you have a disability question, pocketemploymentlawyer.ca is also a good place to go as well. Disabilityrights.ca, firm website, drop-down menu under the media tab, I believe, and you will find links to our radio shows there as well across the country. James is on the show. We talk about all kinds of stuff when it comes to disability law. We take a lot of phone calls as well. We'd like to play them back here on this show and talk about them a little bit. James, our first call for today is coming up right now.
I have a cousin who's just been diagnosed with cancer. His work has been very, very good so far. They said, okay, we'll use it for vacations and so on, and then you go on short-term disability. So my question is it easy then to get into long-term disability? And if so, how long would long-term disability last for?
Okay, well, that's an excellent question. So typically speaking, the transition from short-term to long-term disability is really an easy process. So it isn't something where you're typically going to have to go through the same hurdles that you go through when you're first applying for short-term. Usually, if you have the entitlement to get short-term disability benefits, there is already an internal process set up for a transition. So if you're dealing with the same insurance company, often you don't have to do anything. Often it's just something that the insurance company will move it from the short-term department to their long-term department, and they may ask for updated records if they don't have anything that's a little bit more current, or they may not. It may just be a very simple transition. But believe it or not, even when you have a different insurance company, or sometimes it's the employer that pays short-term disability benefits, and another insurer for the long-term benefits, even then, more often than not, the transition's pretty easy. You might have to fill out a couple forms. You might have to fill out the same forms that you did initially, but that's not terribly onerous, and typically speaking, it's not something that you need to get too concerned about. Now, in terms of the other part of that question, how long can you expect the long-term disability benefits to last for? So during the first 2 years, after the short-term disability benefits are over, you have 2 years of that own occupation test. And we were talking about that earlier in the segment, where the test is whether or not you can return to your own occupation. And a lot of times people internalize that and believe that means that their policy is only for 2 years, that you only have 2 years until your benefits run out, and then they're going to stop paying you automatically. And that is absolutely not the case in a standard LTD policy. In a standard long-term disability policy, you are entitled to receive benefits until you are 65 years old. old. The test changes after 2 years and does become a little bit more difficult. It goes from the own occupation test to the any occupation test. But that certainly doesn't mean you're no longer entitled. It just means it becomes a little bit more difficult. But really, it's not something that you should lose a lot of sleep over. Most people shouldn't be cut off at that 2-year mark. There are situations where it might apply, but for most people, that 2-year mark isn't really going to have a significant impact on whether or not they're entitled to their benefit.
Maybe if you're 63 and it goes till 65, then
well, sure,
yeah, right? But I mean, that
sure.
math.
If you have a purely physical disability,
right,
and you also at the same time have qualifications or education that would allow you to do a more sedentary job, in those situations, yes, the 2-year mark may well be the cutoff point because the test changes, and if you are capable of doing a sedentary job and passing that commensurate earnings test, yes, that will be a situation where the insurer is absolutely entitled to apply the new test and cut you off. But most people, that's just not the way it plays out. Most people, it's not strictly a physical disability, typically speaking. Even if it starts that way, there enters in some mental health issues. And even if it is purely a physical issue, if they are doing a physical job and earning good money, and they don't have education and experience that allows them to be able to pass that commensurate earnings test, to get 60% of what they had been making before, then they're not going to be in a position that they're going to be able to go back to work, and the insurer is going to have to keep paying them.
Again, disabilityrights.ca, one of many websites we offer up. That one to find our radio shows where we just played that call from. We'll do another one a little later on the show, but we got to take a short break, a quick one here. The number 1-855-821-5900. What to do when you're returning to work off LTD. We will tackle that after the break on the Disability Law Show. Stick around. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. This is the Disability Law Show. Once again this week, good to have you along. John Scholes, James Fireman as well from Samfiru, Tumarkin, LLP. You want to reach out anytime, just have a discussion, learn more, right, from James or a member of his team. Simple, 1-855-821-5900, help at disabilityrights.ca. All right, James, question time. I'm going to run through these. What you need to know about returning to work from LTD. Number one, claimants should only return to work when they are approved to do so by their doctor and or medical team, right?
That's absolutely correct. So the decision on when you return to work is not a legal decision, which means it's not something that you should be leaving to your insurance company to decide, and it's not even something that you should be relying on your lawyer to decide. Right. It's a medical decision, which means you make that decision in conjunction with your doctors. When your doctors say that you are medically fit to return to work, that is when you start the return to work process. And even then, I tell my clients that even when they have medical approval, they should really be focusing on making sure that they don't start that process until they are personally optimistic that they're going to be successful. If they feel like they're not going to be able to succeed in trying to return to work, then they likely aren't. And so if their doctor is saying, well, you know, you can try if you want, you might be able to do it, you might not, and they feel like they're not going to be able to do it, I don't tell them that they should go back in those situations because it's unlikely that they'll succeed. On the other hand, with most of my clients, they are looking to go back as soon as possible. Yep. And if you feel like you are ready to go back to work, you're feeling good, and your doctor says okay, then you should do it. I'm not saying you have to be 100% sure. You know, no one has a crystal ball, and no one knows for sure what the future holds. But if you feel optimistic and you have medical clearance from your doctors, absolutely give it a shot. You are much better off if you are working, earning 100% of your income, than you are trying to recover 2/3 of your income from an insurance company.
the second part of that where you said, with your doctor's blessing for all intents and purposes, what if you're like, hey, doc, I know you're saying I probably shouldn't go back now, but I'm feeling kind of Superman. I'm going to try it anyway.
Well, listen, it's up to you. You got to make the decisions that are in your best interest, but I strongly discourage anybody from ignoring their doctor's medical advice in any situation, but particularly in that situation. Because whether it's a physical issue or a mental health issue, if you go back before you are medically cleared to do so, you are taking on that risk on your own. Right. Anything that happens to you at that point, you're really on the hook for. And so if you go back too early and you make your situation worse, that's on you. That's on you. And your insurer may not want to cover you beyond that. And they may be correct in that.
Yeah. We're talking about things you need to know if you're returning to work from LTD. Number 2, necessary accommodation and limitations must be observed and communicated to your employer, right?
Yeah, that's absolutely true. So you want to make sure that when you talk to your doctor, that your doctor canvasses all of the restrictions and limitations that might apply to your particular situation. And so that's going to require your doctor not only to understand your medical condition, but also to understand what your duties and responsibilities are at work. What do you have to do on a day-to-day basis? Is there a physical component to it? Are you required to even go up and down stairs? Are you required to walk around a certain amount of the time? Or are you required to sit in your cubicle for 8 hours a day? Whatever your situation is, your doctor has to understand what is normally required and then apply what medical restrictions and limitations you have to your job description. And so they may say, yes, you can try going back to work, but you can't lift more than 40 pounds, or you need to have the opportunity to
sit down every half hour.
Or to change positions every half hour, whatever the case may be. Or they may just say, yes, you can try going back to work, but first we want you to start slowly, so 2 days a week, no more than 4 hours a day, and gradually over typically 8 to 12 weeks, increasing the days and the hours until you're up to full time, checking in every couple of weeks to make sure that you're progressing well. And so whatever those restrictions and limitations are that your doctor says are necessary for you to try returning to work, those have to be communicated to your employer, and your employer has to agree to those. If your employer is not willing to agree to the limitations your doctor is saying are necessary for you to try and return to work, then you shouldn't be going back to work. Because essentially what you're doing is you're pushing yourself beyond your medical capabilities to a point where your doctor is saying it might in fact be dangerous for you to be in that situation. You might be making your situation worse. So that has to be communicated to your employer very clearly. Here's the thing though. This is a situation when you're ready to return to work and your doctor gives you these limitations and restrictions. Believe it or not, this is a situation where your insurance company is actually going to be helpful for you. Because your insurance company, they're very motivated to see you get back to work. They want to see you succeed in going back to work. So you better believe that a halfway intelligent claims handler is going to be on the phone with your HR department saying, listen, Mr. Smith needs to come back, but this is what he needs. Can you get it for me? No, why not? They're going to be advocating for you in that situation in most cases because they want you going back to work. So they'll be pushing your employer. So when you are ready, when you get that letter from your doctor with limitations and restrictions, go to your insurance adjuster and have them advocate for you with your employer to make sure you get those accommodations that are necessary for you to successfully return.
Now, I did mention earlier with the pocket employment lawyer, there's a lot of crossover and bleed over between employment law and disability law. I think this is one of those cases where I'm sure you've had this in your practice, James, where the employer says, yeah, okay, we get insurance company. Thank you, James, appreciate that, but no, we can't do it. There's a pretty high threshold as far as what the employer has to do when it comes to accommodation. I know we're getting into employment law, but you've got to deal with this too, right? Yeah,
absolutely. And so if the employer is not willing to play ball, then we have a decision to make. We have to decide whether or not whether or not the situation allows us to bring in the employer as well to engage with them, or whether it makes more sense to back off and say, well, no, he can't return or she can't return because the employer isn't willing to accommodate. You're still on the hook for benefits, insurer. So those are two options that you have in that situation. You can either push the employer or push the insurer, and it really depends on the situation. And we'll make an assessment on whether or not the employer is being reasonable or not. And depending on the situation, depending on what our clients want, we'll pick one route or the other.
Again, we're talking about what you need to know about returning to work and coming off LTD. Claimants who do attempt to go to work but are unsuccessful should be able to resume their LTD benefits, right?
Yes, that's absolutely correct. So there's what we call a recurrence clause that's built into virtually all standard long-term disability policies. And so the recurrence clause, what it means is that if you are disabled, you're getting disability benefits, and you get to a point where you're actually ready to go back to work, and your doctor says, okay, you can go back to work, here are your restrictions, limitations, and your employer's on board, they give you the accommodations that you need, and you go back and you try, but you're just not able to do it. Right. In that situation, most policies have language that says in that particular scenario, you're not going to have to reapply for a new disability claim. You're going to be entitled to re-engage your existing claim and get your benefits starting as soon as you stop working again, which means no elimination period. Usually when you apply for disability benefits, you're waiting 4 months, 6 months before they kick in.
Wow.
If you've been on disability and you try going back to work and you're not successful, the recurrence clause allows you to re-engage your disability benefits right away without waiting for that elimination period, which is great in theory. In theory, that's great. Okay. In practice, the insurers rarely will abide by that recurrence clause. More often than not, they will, as soon as you say you're ready to go back to work and you make the attempt, they are going to use that as justification for terminating your claim. And even if you attempt and you're not successful, they will rarely actually put you back on claim as they're required to do, which means that you're going to have to bring a legal claim, which means you give us a call and we'll engage with them and we'll go after them in that way. I say this because I want people to understand that even though this recurrence clause is there, they shouldn't depend on the insurance company actually applying it the way that they ought to, which gets back to what I was talking about earlier. When I say that when you're deciding whether or not you should go back to work, you should only do so when you feel optimistic that you're going to succeed. Because even though there is this recurrence clause, it's rarely applied the way that it should be. So you want to go back when you have the best chance of actually being successful in your return to work.
Lots of good stuff there. Again, if you missed anything or want to follow up, more information, have more of a lengthy phone call or chat with James or a member of his team, here's how you do that. 1-855-821-5900. Email address help@disabilityrights.ca. We'll take a short break, but there is more coming up, so stick around. Disability Law Show continues. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you for sticking around for the half hour. This is a Disability Law Show. John Scholes here and partner at Samfiru, Tumarkin, LLP, James Fireman. On the show today, relaying all the important information. Another outlet for you anytime to ask questions. I give you the phone number. I've given you the email address. There's also a website, mydisabilityquestions.com. The good thing about that is there's a searchable database, which means type something of the nature of your question and look for it. Someone may have asked that question in the past and been answered in full. Save you some time, right? If not, leave the questionnaire. James will get a member of his team to answer it, and you can move on. From mydisabilityquestions.com, first one for today on the show. James, Georgiana writes in, says, I am currently on long-term disability because I suffer from PTSD and general anxiety after an incident that happened a year ago. Is my insurance caseworker allowed to specifically ask why I have PTSD? Some of their questions seem intrusive, but I'm worried I'll be cut off if I don't answer them.
It's a really good question, Georgiana. So unfortunately, when you're applying for long-term disability benefits, or in fact for most insurance benefits, your insurer is going to be entitled to ask you a lot of questions, and they have a lot of latitude in doing that because they need to understand the full basis for why you're claiming and whether or not you're entitled. And so whereas with your employer, when you're taking time off from work, they're not entitled to get all of the information, all of the foundational information about why you are sick or why you are disabled.
Yeah.
Right. They're not entitled to that, but an insurer is. An insurer is entitled to evaluate whether or not that particular or your particular issues are sufficient to pass that either own occupation test or the any occupation test. And it's not enough for your doctor to just say that you are disabled from working without giving more detail, without providing their clinical notes, because the reality is, we all know this, doctors often disagree. Put two doctors in the room and they may often come to a very different conclusion about what the same person is suffering from, or what the prognosis, more importantly, is going to be. And so the insurer is entitled to have their own doctors provide an assessment and to give them information that will help them to adjudicate the file. So yes, it's unfortunate, but the reality is, if you want to bring a claim, then you have to swallow that pill. You have to be willing to share that information with your insurer. Now, that doesn't mean that there are no limits. There are limits on what they're entitled to inquire on. And so one of the things that comes up rather frequently is issues in the bedroom, issues with sexuality. And so it's something that people are very uncomfortable talking about, and for good reason. So is the insurer entitled to know that you're having dysfunction? Sure. But they're not going to be entitled to understand the details behind that.
Right.
And so there is a line that is drawn. They're not able to ask you anything, anytime about any particular issue, but they are entitled to understand at least what is happening, what the issues are in your life, especially when it relates to your ability to work.
If there's some conflict, as you mentioned, between, say, your medical team and the insurance's medical team, which you got to assume that the insurance doctor either has not seen you or seen you very briefly, is your medical team kind of taken as correct because they've been treating you for so long?
Yeah, your treating medical doctors are going to almost always be preferred over whoever is hired by the insurers. The insurers usually aren't going to send you to a doctor for assessment. Usually, they're just going to, at most, send your file to a doctor for a paper review. But even if they send you to a doctor for assessment, that doctor is going to see you typically once, usually for an hour or less. Sometimes it's 15, 20 minutes. And so even if that doctor that they send you to is a qualified specialist that is in a relevant field to whatever your dysfunction is or your disability is, that doesn't mean that their opinion is going to carry more weight than a similar doctor with similar expertise who's been treating you for a year or 2 years or however long it's been. They are obviously, your treating doctor is obviously in a much better position to comment on that.
Got 2 minutes. I want to get through this email quickly from Jalen. She says, my 42-year-old sister has been on LTD for nearly 2 years. She has chronic back and knee pain from the work she's done all her life in an auto factory. The insurer recommended physiotherapists think she is better and able to go back to work. However, her own family doctor disagrees. Now the insurer says she must return to work or they'll end her benefits. Can they do that?
Well, that's a very interesting question, especially in the context of the last email that we just read. And so here, it's not a dispute between your treating doctor and the insurer's doctor. It's a dispute between your treating medical team. Right. Two different physicians, one's a physician, one's a therapist on your medical team. And so it's easy to say that your doctor's opinion is going to be provided more weight than your therapist. And often that will be true. And it's understandable. The doctor has more education. They've spent more time in school. And there is a cachet to an MD that you don't have as a therapist. That's just something we know, fairly or not. But the reality is that a therapist may have much more hands-on time with you and may be in a better position. In that situation, what I would suggest, in fact, is your doctor, your family doctor who's on board already, sends you to an orthopedic surgeon to get an opinion. And if that orthopedic surgeon agrees, then you're good to go. That is the opinion that should carry weight. You're probably going to have to bring a claim to challenge it, but it is still something that is repairable. It's something where your medical team can absolutely support you in that case.
Good stuff for another day. Thank you, Jalen, for that email. You want to send one along now that we are wrapping up for this week. It is help@disabilityrights.ca. Phone number anytime, 1-855-821-5900. And before that, I refer to it. You can use that as well. That would be mydisabilityquestions.com, mydisabilityquestions.com. And of course, COVIDrights.ca, because we're still in a pandemic, so you can get some more information there as well. We'll catch you next time. Disability Law Show. Thanks for watching.